Hello everyone, welcome to a class today. So today we are going to learn about public prosecutors and police. Okay, so we have already in the chapter 4 we had started with the concept of the courts, the classification of the courts, their powers, their functions, all that we have already we have dealt with that. So today we are going to learn about the public prosecutors and also regarding the institution of the police in a very introductory manner we are going to learn. Okay. See here, when it comes to the court, okay. So we have the court here. So suppose a person is accused of an offence. So he has committed an offence towards a person, towards a victim. He might have hurt him, he might have murdered him, or his relatives, he or his relatives could be the victims, right. All the victim goes and files the complaint. It is the state or it is the government who is going to conduct this case against this accused, because whenever a person commits an offence, it is not only towards an individual, it is also against the government itself. Okay. So when it is against the government is going to conduct the proceeding against this accused person. That is why it is known as state versus accused. See, in all civil proceedings, it is always the individual, right. Individual is representing individual. Ramesh versus Suresh, Naina versus Kamala, like this we see. But in criminal proceedings, it is always the state versus accused, except in some private complaints, private names will be there. But in all other cases, if it is a case instituted upon a police report, then it is the state represented by a particular police station, they are going to conduct the case, right. So who actually, it is the government, but who is actually in charge of that? It is the prosecution, or we have department of prosecution, and this is the department which deals with the conducting the case against the accused, and they argue. So there will be a panel of advocates who are called as the prosecutors. There could be additional public prosecutors. There could be assistant public prosecutor, there could be special public prosecutors. So we have different types of prosecutors who represent the government in the court, in various courts. It could be in high court, it could be in a sessions court, it could be in magistrate courts also. Okay. So that is why they have been designated likewise. So when it comes to this, okay, when the public prosecutors we say, see, we have different category: public prosecutors, assistant public prosecutors, special public prosecutors, and Directorate of Prosecution also we have. So this is a very special category because this has been reorganized in a very structured manner in this case. Okay. So see here, this is the Directorate of Prosecution. This is what we see. So here in this Directorate of Prosecution, they have also set up Directorate of Prosecution we have. So this is what we see here. So let us understand them one by one. Who appoints the public prosecutors? What is the minimum criteria? And for the eligibility for special public prosecutor, who are those? Well, we'll see. We'll see them accordingly. See, I hope this is visible to you. Okay. So let us understand about the public prosecutor. See, public prosecutors, they are advocates who are practicing in high courts also, because they are appointed. First of all, they should be appointed as prosecutors, and they will be designated in different courts. Okay, that could be in high court, that could be in sessions court. So public prosecutor and additional public prosecutors, they will be conducting the cases in high courts. Public prosecutors for district, they will be conducting the cases in the sessions court, right. So for the qualification is, for all of them, they need to be advocates, at least they need to be in a continuous practice as an advocate at least for 7 years, minimum 7 years they should have practice as an advocate, and central government or state government appoints them. And in the case of high court public prosecutors, appointment will be done by the state government or central government in consultation with the high court. And in case of state level district level public prosecutors, see, there are two types. One, there could be panel which is appointed by district magistrate and the sessions judge. That is one side, one thing. Or see, already in our state we have a very structured department of prosecution. They are appointing the public prosecutors, they are like conducting examinations, and there are different cadres of public prosecutors as well. We have properly selected, appointed for the post. So, okay, one, there could be different panel, that could be set of advocates who are named as prosecutors, or there could be proper mechanism for the appointment of the prosecutors themselves. There like hierarchy, according to seniority they are going to be appointed, because see, in different states there could be different procedure. Ultimately it is a state government which makes laws regarding the appointment of the public prosecutor. Okay, so they have suggested two options, either there could be panel which is prepared by the district magistrate or the sessions judge, or there could be a separate cadre of public prosecutors who are being designated according to their promotion or regular cadre. They will be constituting that cadre. Okay, so ultimately the conclusion is, public prosecutors or additional public prosecutors, they need to be qualified. In order to be qualified as PP or APP, they need to be an advocate who was in practice for a continuous period of 7 years. Okay, that is the need. They could be practicing in High Court also, they could be practicing in Sessions Court also. Then comes Assistant Public Prosecutor, APP, what we call. So, APP also we have a separate mechanism, but sometimes what happens is, some other persons could be appointed as police officer as well. Sorry, some other person could be appointed as public prosecutor, APP as well. So, even a police officer can be appointed as APP, right. So, how can a police officer can be appointed as an APP? So, if in case or actual APPs are not getting, and if any other person being appointed as a police officer, then they have to be intimated within 14 days. 14 days they have to intimate the state government or the central government, and the police officer shouldn't be a person who has conducted the investigation, and he should not be below the rank of inspector. So, the case is very simple. See, sometimes what happens in a magistrate court, assistant public prosecutor is such person who is going to conduct the case, conduct the proceeding in magistrate court. So, in the magistrate court, if the person is not available, APP is not available, then any other person also can be permitted to be APP, but he should be properly appointed. So, when such things are needed, 14 days notice has to be given to the state government. Sometimes police officer, I am so sorry, sometimes police officer also can be appointed as an APP, a very unique thing, okay. Even a police officer can also be appointed as APP for a particular case, but the condition is that, see, he himself is conducting the investigation, and he himself is prosecuting he himself as an advocate, he is continuing the proceeding. Would that be good? It is not just, right. So, investigating office should be different and APP should be different. So, if a police officer has to be appointed as an APP, he should not have investigated the case, okay, that is one thing, and he should be of at least the rank of inspector. He should not be below the rank of inspector. Minimum he should be of the rank of inspector category, right. So, this is one very important major thing what we call it as. And then comes the special public prosecutor. So, special public prosecutor is such person, for specific purpose he is being appointed, okay. Special public prosecutor, he will be appointed for a particular purpose. For his appointment, he need to be in practice for 10 years, minimum 10 years he need to be in practice as an advocate, okay. That is very, very important. Remember, for all others it is 7 years, and for APP they haven't specifically mentioned about the qualification, but they have mentioned if police officer has to be appointed as APP, then they have given the qualification, because APP usually the government will appoint as per their rules and regulations. They have a separate rules for that. But in the case of special public prosecutor, he needs to be in practice minimum for a period of 10 years, and he could practice in any court, and APP will be practicing in court of magistrate, okay. So, this is one important classification which we need to understand. So, what all we learnt? We learnt about public prosecutors, additional public prosecutors. They could be conducting the cases in High Court, they could be conducting the cases in District Court. That is one thing. And we also learnt about the assistant public prosecutors. And also we are learning about the special public prosecutors. So, these are different categories, and over them, above them, we have Directorate of Prosecution. So, already there was a Directorate of Prosecution, but now as per BNSS, it has been greatly reorganized, because in every district we see that District Directorate of Prosecution has to be established, and there some deputy directors, assistant directors should be appointed. So, that is a great change what we can observe. We like in paper we won't see much change, but institutionally there are a lot of appointments which is going to happen. Every department is going to be established in a district. So, they are overlooking the cases, they will expedite the cases for the quick disposal of the cases. These departments will be of very useful. So, this is a chart regarding Directorate of Prosecution. Okay. Directorate of Prosecution is a department which is overlooking the work of all these persons like PP, APP, additional PP, assistant public prosecutor, special public prosecutors, etc. So, who are the persons, like what is the establishment? It is the state government which is going to establish Directorate of Prosecution. Okay. So, at the state level we have Directorate of Prosecution, and this was already there in CRPC also, but now as per BNSS they have stated that in every district there will be District Directorate of Prosecution. In every district they will be there. So, in every district if Director of Prosecution has to be there, so even that is established by the state government. Okay. So, state level Director of Prosecution consists of the director, he is the main person. Director of Prosecution will be there, along with him Deputy Director of Prosecution will be there. Okay. One is Director and others are Deputy Directors of Prosecution will be there. In the district level we have Deputy Directors, along with him Assistant Deputy Directors of Prosecution will be there. Okay. See the classification, this could be a very important question, because this is a very new concept which has been included, and it was there, but at a district level it brings major changes. Okay. So, please remember, at the state level we have Director of Prosecution and Deputy Director of Prosecution, and at the district level we have Deputy Directors and Assistant Directors of Prosecution. Okay. This is one thing, this is one such thing what we understand. Then to become, like what is the eligibility for becoming Director of Prosecution or Deputy Director? The person should be practicing as an advocate at least for 15 years. This is the requirement. For minimum 15 years he should have practiced as an advocate, or he should have been a sessions judge, district level judge he has to be, to become Director or Deputy Director of Prosecution. And in the case of to become Assistant Director of Prosecution, he need to be at least have 7 years of practice as an advocate, or he should have been Judicial Magistrate of first class. He should have served as Judicial Magistrate of first class. That is the requirement. Okay. So, for at least 15 years practice he should have, or he should have been a sessions judge, or at least 7 years practice he should have as an advocate, and he should be of a magistrate court. So, this is one thing what we have seen, and then comes regarding subordination. Who is subordinate to whom? Like, see, all these persons, they work under the Home Department of Home in the state level. So, under that department, the Director of Prosecution, subordinate to him is Deputy Director of Prosecution, subordinate to him is Assistant Director of Prosecution. So, the main department is the Home Department, below that Director, below that Deputy Director, and below that Assistant Director. And subordinate to these agency we have Public Prosecutor, Additional Public Prosecutor. This is not Assistant Public PP, this is Additional Public Prosecutor or Special Prosecutor who are working in High Court. Then subordinate to them are Public Prosecutor, Additional Public Prosecutor or Special Public Prosecutor as per District Court, and subordinate to them are Assistant Public Prosecutors. Okay. So, this is one such major this one what we have understood. And then what are the functions of powers of this Directorate of Prosecution? See the overall, if we see Director, Deputy Director and Assistant Director, we see that the main function is, they have the main power or the function to monitor the cases. So, Director will monitor cases punishable with about 10 years or life or death punishment. Okay, he will monitor those cases and he will try to dispose the cases, to conduct the cases. He will instruct his juniors to conduct the proceedings very quickly, and he also gives opinion on filing of appeals, whether to go on appeal in this case, whether they should go or not. So, they give opinion regarding this. So, this is regarding the Director of Prosecution, his powers and functions. Then Deputy Director, what does he do? He monitors the cases which are punishable between 7 to 10 years. So, this person more than 10 years, this person between 7 to 10 years, he will monitor such cases and he will see like a quick disposal of cases is being done, and also he will examine and scrutinize police reports. He will check what does this police report say. So, all these things, it is being done at district level, right? Deputy directors are there in district level only. So, that is why they will scrutinize the police report properly. And when it comes to Assistant Director, he monitors such cases which are punishable for less than 7 years, okay, which are offences punishable less than 7 years. For them, he will be monitoring the cases. Yes. Then, when it comes to other powers, okay, all these persons, Director, Deputy Director or Assistant Director, they have the power to deal, okay, regarding all proceedings under this Samhita. Power to deal, and they are responsible for whatever proceedings it is being done under this BNSS, they are responsible. And when it comes to other powers and functions, state government may prescribe them by rules. And you must also be knowing, see, there is a constitutional head who is known as Advocate General, right. So, he is the legal, he gives the legal opinion, he is a legal advisor to the government. So, sometimes he may act as public prosecutor also, right, he may act as public prosecutor also. So, when that is the case, the Advocate General is acting as public prosecutor, then all these rules will not is not applicable to him, because he works under the constitution, not under CRPC. So, particularly they have stated Advocate General, he is not responsible, or for him these cases are not applicable. Public prosecutor, although he is working as public prosecutor, but the post of Advocate General, for the post of Advocate General, these rules are not applicable. Okay? Yes. So, this is one such important thing what we have seen. And the next one, yes. So, this is regarding prosecution. So, to summarize it, we have learnt about different positions of prosecution, that is public prosecutor, additional public prosecutor, assistant public prosecutor and special public prosecutor, and we have also learnt about the Directorate of Prosecution, which has been reorganized in a very structured manner under BNSS, where District Directorate of Prosecution, that has been the new change, where it consists of deputy directors and assistant directors of prosecution, and the powers and functions have been clearly mentioned. So, according to the seriousness of cases, director, deputy director or assistant directors, they are working, right. So, this is one category what we see, and then comes about police. Okay. See, police, the institution of police, how do they work? So, there is a central act which is known as Police Act of 1861, but what happens is there is also another act, every state act, okay, Karnataka Police Act we have. For an example, the state government are having the power to enact their own law and repeal the Police Act for their state. So, likewise, Karnataka is having its own act, or Madhya Pradesh is having its own Police Act. So, likewise, okay. So, we have Karnataka Police Act of 1963, right. So, it is an instrument for the prevention and detection of crime. So, what are they going to do? They will, of course, they will prevent the crime, and if in case crime has taken place, they also detect the crime. Okay, that's very instrumental in the prevention and the detection of the crime. And who is the head? Who is the head in the state? It is the, this could vary in different states. Okay, generally they say Inspector General of Police or Director General of Police. He is the head at the state level. So because it's a nodal agency, right? In every state the police department changes. Karnataka police is different, Delhi police is different, or Punjab police is different. It could be different. So this varies, but there will be one particular head of the police who is said to be Director General, or he could be also called as Inspector General. In Karnataka, it is Director General and Inspector General of Police. Okay, I am giving the example of Karnataka. He is the head of the state, Director General and the Inspector General of State, Inspector General of Police. And at the state level and at the district level, they have Superintendent of Police, District Superintendent of Police, or you can call it as SP. SP is there. So this is a basic organization what we can understand, and like why is their position necessary? Because see what happens is, so this is a general hierarchy. It could vary. I am already saying, because different states have their own rules. They can create a new post also, they may delete some post also, but generally it is the Director General, Inspector General, they are at the top level. Then comes SP, who is at the state level. He is at the state level. SP is at the state level. Superintendent of Police at the state level. Then at a district level or taluka level, for every station, for every police station, either inspector, or we can also call it as circle inspector, he will be the head, like station house officer, SHO we call, or there could be sub inspector of police also for a particular station, SHO we call it, we call them like that also. And then it could be assistant inspector, head constable, senior constable likewise. So he is at the district level, SP is at the district level, and all these persons are at the state level, District General, sorry, Director General, Inspector General. So this is a general classification. The reason is the powers and functions of the police is that, what do the police do? They receive information. Whenever an information comes to them regarding the crime, they receive them. So they classify according to cognizable offence, or they may also classify as non-cognizable offence. When there is a cognizable offence, they can directly start investigation. They can directly start investigation. They can arrest. They can also arrest a person. Okay. But when there is a non-cognizable offence, when it is a non-cognizable offence, what happens? The police officer directly cannot start an investigation. What can he do? He has to ask the magistrate. He has to take the permission of the magistrate. He has to take the permission of the magistrate, and then if the magistrate gives permission, only then he can start investigation. He can start the investigation. Okay, so because of this, if he does not accept the information, then he can directly complain to the SP, Superintendent of Police. So that is where that's why we need to understand the posts, like who is superior to whom, who is subordinate to whom. So he is the Superintendent of Police. So the information is received by the officer in charge of the police station, or we also call it as SHO, Station House Officer. So it could be officer in charge of the police station, could be inspector or SI, right? Sub Inspector of Police we call. So if they do not receive the complaint, then it will directly, what will happen? They can go to this one, Superintendent of Police. They can appeal to Superintendent of Police. Yes. So this is one such thing, arrest and investigation. And the police have many such powers. They can conduct search. So when they receive information, they can start investigation. In the process of investigation, they can conduct search. And what else they can do? They can seize certain properties, or they can arrest. As I already told, they can arrest a person, and they can examine the witnesses, examination of witnesses can be done. They can examine certain persons. And sometimes what happens, there could be a case of unnatural death. When there is an unnatural death, they have to conduct the inquest. Inquest they have to conduct. Okay, they have to conduct the inquest. So all these things are there where we can see the police are having vast power. Okay, they have vast power in different cases. They see earlier there was a provision of weights and measures. The police could detect if false weights and measures are there. They could take action, but now those provisions have been repealed because we already have a separate act, Legal Metrology Act is there. So according to that, what we can do, according to the Legal Metrology Act, they are going to deal with the false weights and measures. So as the necessity of such weights and measures are not found, they could be dealt, they have been repealed here, and they have left to deal with Legal Metrology Act itself. Okay, that is one such thing. And sometimes police are having the power to prevent, they can detain certain persons if the direction is not obeyed. They have the power to detain. That is a new provision which has been included. So we see different aspects over the time. When we understand different chapters, we will come to understand like how vast the police power is. Okay, this is a just introductory portion where we are learning what are the police powers. Okay, see. So they are having the power to make arrest, search, and the person who is in charge of the police station, he is having a main role, okay, regarding search, inquest, receiving information. So many things they are having producing the person in custody. They cannot detain a person more than 24 hours. They have to inform the persons when an arrest is made. So they have certain duties also. And only one drawback which they don't have, which they have is, they cannot directly investigate into non-cognizable offence. Okay, they cannot directly investigate into non-cognizable offence, and see, they have the jurisdiction also. Jurisdiction will be determined as per 197 and 198. So wherever the offence has been committed, or if it is uncertain, in all such cases, they get the power to investigate a case or to register a case. Even if it is filed in some other jurisdiction also, they get the jurisdiction to entertain that case. Okay, so these are some of the powers of the police. So this is all about what we have learnt so far. It could be regarding the prosecution and it could be regarding the police. Okay, both are equal, prosecution and police. Regarding police, we come across various sections meanwhile. Okay, whenever we understand different chapters, there definitely different powers of police will be given. Okay, yes. So prosecution I have already discussed, police also have discussed, and the courts we have discussed in a previous class. So this is regarding the main institution. Okay, and also we have defense counsel, right? The person who is represented representing the accused, he is known as a defense counsel. He could be any advocate. He is known as a defense counsel. Sometimes if he is very poor, legal aid is provided to him. Right? Yes. So this was all about this chapter. So in next class, we will understand about what is FIR, how the cases are initiated. Regarding all these things, let us understand. Okay. So thank you for your patient listening and see you in my next class. So take care. Bye bye.